Welcome viewers to the Personal Injury Law Show. This is a show that talks about anything to do with personal injuries, that is car accidents, work accidents, slips and falls, medical negligence. My name is Tony Carbone, lawyer with over 25 years experience in personal injuries. With me tonight I've got one of the youngest partners in the law firm, Nunso Taptaya. Good evening, Nuns.
Tony, Sarah, viewers, good evening.
And also a fabulous young lawyer in the name of Sarah Snowden. Good evening, Sarah.
Evening, Tony. How are you?
Viewers, tonight we'll be talking about superannuation and your rights and entitlements under your funds.
Before we do that, let's take a look at what's in the news, guys.
What's in the news tonight, viewers, is we've got this interesting matter of a young girl that went on a cha-cha ride. I think everyone knows what a cha-cha is. That's that ride that goes round, doesn't it, Sarah?
Yep.
And it spins the person around at the
That's
same
right.
time. Now, it was at the Lilydale show, and this young teenager's on the ride, Nonce.
Yep.
And then what happens?
Well, the show operator failed to secure the ride, and as obviously it was going round, she's been flown off, I think, together with her cousin, and flown for metres and hit a railing.
So, by failing to secure it, what is it? The bar didn't come down, is that correct?
Yeah, I think it was down, but it wasn't properly secured in terms of it was latched on. And then she's been flown and had dramatic injuries.
She's lucky to be alive, isn't she, Sarah?
Very lucky. It's quite concerning to think that something like this could happen at, something that's meant to be a fun day out for the family.
Well, the reason why we wanted to bring it up, viewers, is that apart from the fact that this young girl has sustained a nasty scar and other psychological injuries, WorkSafe, who were approached by the papers, said that they're not going to investigate this case. Why?
Well, couple of reasons why. Two, I suppose, to give a bit of background for the viewers, the operator of the show is based in New South Wales. The company that operates it is a New South Wales company. Now, what WorkSafe says is that two things. One, that it's not in their core area. I'm not sure how this could not be in their core area. And two, because it's outside the scope of Victoria, it's, I suppose, not in their jurisdiction, which we're dealing with safety of children, which is probably the most important aspect going around, and that's not important enough for them.
What's astounding for me, Sarah, is that I guess they could have easily been killed in this incident.
Absolutely.
And then would that have been in their core area?
Oh, it's quite an interesting question, Tony, as to whether or not WorkSafe would have investigated had there been a death that had resulted from this accident. And it's quite concerning that, given the equipment and obviously the result from these young girls being thrown from it, that the WorkSafe's not considering investigating to make sure that it doesn't happen in the future.
Well, it's a pretty significant breach. Anyway, show on you, WorkSafe. Next story. Smokers get the flick. What this means, guys, is this. There's been a lot of people out there, that is employers, who are putting up ads to say, if you're a smoker, don't apply for a job. What do you reckon, Hans?
Look, it's a form of discrimination in my eyes. Look, I'm not a smoker, but I can't see how somebody, smoking has an impact on their ability to perform a job. I think it's gone too far, Tony.
What if the person is applying for a job in the health system? How do you feel about that, Sarah?
I think that would certainly, depending on what type of work they're doing in the health system, would certainly impact on that, especially if they're in a position such as with the Cancer Council, or they're promoting some form of anti-smoking campaign, and they're caught on camera or they're seen in public to be
belligerent in terms of
that's
health.
right, in terms of that. So I guess it could have an impact on their ability to actually perform their job adequately as well.
Okay, my concern as an employer is that I've got a lot of people that are non-smokers coming to me and saying the smoker is taking so much time out to smoke. Let's say they have their 10 cigarettes a day, and on each occasion they say take 5 to 10 minutes. The non-smokers are saying, hey, hold it, why they got that privilege and we don't? Is that a concern?
It is, but I think that's a different... it's going away from what this story is saying. They're saying we're just not employing you because you smoke. There's a difference between saying, well, I've employed you and you're taking too many breaks. I think that can be enforced, but in terms of, look, you're good enough for the job, but you smoke, so I'm not employing you, but that's wrong.
Well, the state is saying that they want to implement a law that prevents you from smoking outdoors. Well, that effectively says you can't smoke, doesn't it? So
basically, considering that most restaurants, shopping centres and the like in Australia now have banned indoor smoking or smoking in covered areas, if smoking was to be banned in outdoor areas, it basically means that that people have got nowhere to go to do it.
It may be that employers might have to pay for people to try and quit. Anyway, let's keep moving. on the issue of superannuation, I want to go to a case of Tversky and total risks management. Before we do that, do you want to give us some basic background on superannuation, Sarah?
Yes. The superannuation, everyone has it. Employers are required to make payments of contributions to a superannuation account for retirement of all employees. Generally, most people attached to superannuation will have a form of insurance, Tony. So either in the form of income protection or a lump sum for total and permanent disability or death. And that depends and varies between the funds based on their age, what industry they're in, and how many units they take out. Some funds offer voluntary contributions and towards insurance so that you automatically have cover. Others will ask you to pay for extra units to build up the cover.
And some of these policies are worth a lot of money, aren't they?
Oh, big money, Tony. Look, the recent one that I saw was around $700,000, so we're talking big dollars.
So effectively,
they're not insignificant.
You've got a lot of people that have probably got better rights under their funds than a common law if they get injured.
Well, we've had plenty of instances where, you've settled a work cover common law claim, which, for a certain sum, but the TPD policy is a lot less. Or worth more or less, but it's significant either way.
Let's get on to this case of Tversky. Sarah, can you give us the facts?
Yep. The gentleman injured his back in mid-1980s, continued working intermittently, had some difficulties, did some light duties, eventually had to stop work because of his injuries in about 1998, so he did continue for a little while at work still. At that time, he was offered a voluntary redundancy, which he accepted from the company. He subsequent to that then lodged a claim for TPD benefits or total and permanent disability benefits pursuant to his insurance with his superannuation fund. Unfortunately, the fund determined that because he'd had accepted the redundancy benefit that he did not satisfy the definition. He subsequently reapplied on several occasions for it to be reviewed, and on three or four times,
I think
it was rejected. He then made an application to the court to have the matter determined.
Before we get to that, Sarah, can I just... Nuncio, when he voluntarily applied for this redundancy, didn't he... There was argument or conjecture about where he ticked the box that he was ill health.
Yeah, look, there's a lot of uncertainty around the way in which I suppose he accepted this redundancy, because it is, I suppose, mentioned in the case that he did mention that he had some sort of disablement, that he had some physical limitations with regard to his job.
That's
and,
right.
The employer didn't take that position, but he was adamant in that he did fill it out in that way. And it was very uncertain with what happened.
But what was surprising for me, Sarah, was that when he made application the third time, look, I'll come back to this after the break. Viewers, we've got to get our sponsors break. After the break, we'll go to some interesting facts of this case. Thank you.